Every year, over 25,000 landlords in England and Wales serve legal eviction notices, only to be undermined by the councils that are supposed to help them. Instead of supporting landlords or upholding court decisions, some councils are actively advising tenants to stay put, costing landlords thousands in lost rent, legal fees and mental stress. So here's the question. What happens when a local council tells your tenant to ignore a legal eviction notice and you're left footing the bill? Well, some landlords are fighting back and winning. This could be the start of a landlord revolution, and if you've ever dealt with stubborn councils or delayed evictions, you'll want to hear what happens next. If you want more landlord stories and housing insights that the media won't cover, do me a favour, hit that subscribe button. Now let's get into it. A little while ago, I posted a video exposing how UK councils are advising tenants to remain in properties even after courts had issued eviction notices. That video struck a nerve, and it turns out that some landlords have been fighting back. Let's dive into a real case involving Brentwood Borough Council. A landlord, we'll call him Mr. X, served a valid Section 21 notice in early 2019, wanting his tenants to move out so a relative could move in. He even gave them extra time, all the way until July, but the tenants contacted the council and were told, don't leave unless the court formally evicts you. Mr. X had to go to court. A possession order was granted in July 2019, requiring the tenants to vacate early August, but they still didn't leave. Eventually, the landlord had to apply for a bailiff eviction notice, and the tenants finally moved out in September, months after they were first asked to leave. He racked up court costs, lost rent, and dealt with months of stress. When he complained to the council, they rejected it and told him to contact the wrong ombudsman service. Eventually, the local government and social care ombudsman investigated and found Brentwood Borough Council at fault. The council had to apologise in writing, pay £1,127 for the lost rent, reimburse court costs, pay £100 for time and trouble, share the final decision internally, and retrain staff. More winning cases across the UK. This isn't just Brentwood. Councils across the country have been caught giving poor advice. In 2022, Southend-on-Sea Council paid a landlord nearly £2,000 after advising tenants to stay post Section 21, causing weeks of delays. A 2020 Nottingham City Council case involved delays even after the possession order. The landlord received compensation for stress and lost income. Redbridge Council was reprimanded in 2019 after instructing tenants to remain, leading to months of unpaid rent and legal battles. And in 2021, Croydon Council was found at fault for telling a tenant to stay put, even though the landlord had followed the full legal process. Compensation was awarded after the Ombudsman review. These are just a few of the growing number of decisions stacking up against councils. What does this mean for landlords? So, what can landlords take away from this? Well, councils may be giving tenants bad legal advice. It's now confirmed some councils routinely tell tenants to ignore eviction notices unless the court forces them out. This leads to extra legal costs, delays, stress, and arrears for the landlord. Landlords can win compensation. If the council's advice causes financial harm, you may be eligible to reimbursement via the local government and social care ombudsman. These previous rulings set precedents. Should landlords sue or take class action? Taking a council directly to court is difficult, but not impossible. A complaint to the Ombudsman is more accessible. However, with growing evidence, a class action lawsuit could be on the horizon, especially if multiple landlords in the same borough were affected by the same policy. What do landlords need to win? Well, you need a tenancy agreement, a valid Section 21 or Section 8 notice, court orders and bailiff notices, communications from the council, especially if they advise tenants to stay, proof of rent arrears and legal costs, written complaint and the council's responses. What do landlords lose? Not every complaint ends in a win. Some landlords have lost their cases because they didn't provide their full evidence, the notices were served incorrectly, they failed to keep records of communication, or the council's advice was seen as reasonable based on tenant vulnerability or incomplete information. A case in Birmingham is a good example. The landlord failed to provide court documents when asked, and the council acted within reason based on what they had. Paperwork is everything. Final thoughts. The Brentwood case is part of a much larger pattern. For too long, landlords have been told to absorb the costs when councils intervene, delay or misinform, but the tide is turning. These rulings show there is a path to justice. If you're dealing with a similar situation, don't just sit back. Keep records, file a formal complaint, speak to a solicitor and consider connecting with other landlords in your area. Class actions may not be common now, but with more awareness, that could change very soon. Have you ever been in this situation? Drop your story in the comments. If you found this video useful, do me a favour, hit that like and subscribe button. I'll catch you on the next one.